The Supreme Court chamber was packed that morning. The air carried a quiet tension, the kind that settles before a storm. Cameramen adjusted their lenses, clerks whispered last-minute notes, and the audience waited for the gavel to strike. Today's case, Williams versus Texas Election Commission, was not just another legal dispute. It was a test of democracy itself. At the center of the storm stood Representative Jasmine Crockett, a freshman congresswoman from Texas, invited to present an amicus brief on behalf of voting rights organizations. She was not an attorney of record, but her passionate advocacy had made her a national voice. And seated across from her, at the bench's far right, was Justice Clarence Thomas, the court's most senior member, a man known for his silence and his sharply originalist opinions. Chief Justice Roberts opened proceedings. We'll hear argument this morning in case number 24 to 138, Williams versus Texas Election Commission. Counsel, you may proceed. Crockett stood. Her navy suit contrasted with the dark marble around her. Her notes were neatly aligned, but her voice carried something no paper could capture: conviction. Mr. Chief Justice, and may it please the court, she began, this case is about access, the fundamental right of every citizen to participate in their democracy without intimidation or suppression. She paused. The sentence was measured, deliberate. In that brief silence, the room seemed to lean closer. Texas has introduced measures that disproportionately restrict voting access for minority and low-income citizens, she continued. We contend these measures violate both the Equal Protection Clause and the Voting Rights Act. The Constitution guarantees equality, not convenience, not comfort, but equality. Justice Thomas's eyes lifted from the papers before him. For years, he had been a quiet observer during oral arguments, but when he spoke, it often changed the temperature of the room. He leaned forward slightly. Counsel, he said, his tone low but steady, are you suggesting that states no longer have the authority to determine the manner of their own elections? Crockett met his gaze. Respectfully, Justice Thomas, states do have that authority, within constitutional bounds. But when state policies begin to silence entire communities, it ceases to be governance. It becomes exclusion. Thomas's eyebrow rose almost imperceptibly. And who defines exclusion? You. A faint murmur rippled through the gallery. Crockett didn't flinch. The Constitution does, sir. The 14th Amendment defines it. The 15th reinforces it. My presence here isn't about personal interpretation, it's about constitutional application. Thomas allowed a moment of silence. You speak of equality as if it were a fixed truth, he said. But the framers wrote this document with limits designed to preserve order. Not all regulation is suppression. Crockett nodded. Agreed. But not all order is justice. When order is used to deny participation, it's not governance, it's control. And history has shown us what that looks like. The Chief Justice interjected. Ms. Crockett, you are aware this court is bound by precedent, not public opinion. She smiled faintly. I am, Mr. Chief Justice. But precedent, like power, must serve the people, not silence them. The audience rustled again. Reporters scribbled furiously. Even Justice Sotomayor tilted her head, intrigued. Thomas spoke once more. You appear passionate, representative. But passion does not rewrite law. The Constitution is not an emotional document. No, Your Honor, she replied softly, but it was written by humans, and humans are emotional. The founders debated, feared, and hoped. They knew democracy was fragile, and they entrusted future generations to defend it, not to fossilize it. The courtroom grew still. For a moment, even the clock seemed to hesitate. Justice Thomas's expression hardened. So your argument, in essence, is that interpretation must evolve with emotion. My argument, Crockett countered, is that interpretation must evolve with experience. The America of 1787 could not imagine the America of today. But justice, by definition, must serve the living. Thomas leaned back, crossing his arms. That logic leads to chaos. If law shifts with every sentiment, it ceases to be law. Then perhaps, she said, we must decide whether we serve the law, or whether the law serves justice. The Chief Justice cleared his throat. Representative, let's stay within the record. Are you asserting that the Texas Election Commission acted with discriminatory intent? Yes, Mr. Chief Justice, she said. Through statistical evidence, testimony, and pattern of enforcement, it's clear that the intent and the effect are aligned, both restrict minority participation. Thomas interrupted. Intent is a dangerous word. You presume to know what motivates others. I don't presume, she replied. I listen. The voices affected by these laws have testified. Their words tell the story our Constitution was written to prevent. For a moment, Thomas said nothing. He looked down at his notes, then at the flag behind the bench. Representative, you seem to believe that the Constitution is a living thing. I believe, she said, that democracy is. The words hung in the air, sharp and unyielding. A hush fell over the room. Reporters exchanged glances. Even the marble walls seemed to echo the weight of her reply. Chief Justice Roberts leaned forward. We'll take a brief recess. The gavel struck. As the justices filed out, the murmurs grew into quiet conversation. Some called it audacious, a representative challenging a sitting justice in open court. Others called it necessary. But for Jasmine Crockett, it was neither performance nor rebellion. It was duty. She gathered her papers slowly, ignoring the cameras. Her assistant whispered, "That was bold." Crockett looked toward the bench where Thomas had sat moments ago. "It wasn't bold," she said quietly. "It was overdue." When the court reconvened after recess, the mood had shifted. The initial tension had transformed into something heavier, intellectual confrontation wrapped in decorum. Cameras flashed discreetly from the back rows, and the faint hum of whispers died as the justices took their seats once more. Chief Justice Roberts gave a short nod. "Representative Crockett, you may continue." Crockett stood again, unshaken. The recess had given her time to breathe, but not to retreat. "Thank you, Mr. Chief Justice," she said. "As I was stating before the break, the data clearly establishes that the new voting restrictions in Texas have disproportionately impacted minority and low-income citizens. The intent and outcome, though couched in the language of security, mirror historical tactics of exclusion." Justice Thomas leaned slightly forward. "You refer to data and history," he began, his tone smooth but edged. "Yet you stand here before a constitutional court, not a committee of historians. What, precisely, is the constitutional violation you allege?" Crockett didn't miss a beat. "Equal protection, Your Honor, under the 14th Amendment. The state has applied facial neutral laws that produce discriminatory results. The court has long recognized that intent can be inferred from pattern." Thomas's voice remained calm. "So, the mere existence of disparate outcomes is enough to claim a constitutional breach?" "Not mere outcomes," Crockett replied, "but outcomes consistent with a documented history of racial exclusion, one this court acknowledged in Shelby County versus Holder when it gutted the pre-clearance formula. That decision opened the door we are now trying to close." Thomas interjected sharply. "You're referring to Shelby County, which reaffirmed the principle of state sovereignty, the very cornerstone of our system. The Constitution does not authorize Washington to supervise every election held across the Republic." Crockett nodded. "True. But sovereignty does not mean immunity from accountability. Federal oversight exists precisely because certain states have repeatedly abused that sovereignty to suppress the vote. Justice should not be regional." The Chief Justice's expression remained neutral, but the room felt the ripple. Justice Thomas pressed again. "So, your solution is to resurrect federal control over state elections? Do you truly believe the framers intended that?" She inhaled deeply, choosing her words carefully. "The framers intended freedom, Justice Thomas, not the machinery of suppression disguised as autonomy. The Constitution they wrote gave us the tools to correct ourselves. The question isn't what they intended then, it's what we will allow now." Thomas smiled faintly, a rare sight. "You speak as though the Constitution were a sermon, Representative. But it's a contract. It binds us to words, not feelings." "Contracts require good faith, Your Honor," Crockett said. "Without that, words become weapons." For a moment, silence again filled the courtroom. Reporters scribbled furiously. Even the junior justices seemed transfixed by the duel unfolding before them, less a legal argument and more an ideological battle between eras. Justice Thomas's next question cut through the quiet. "Tell me, Representative Crockett, you sit in Congress, yes?" "Yes, sir." Then why bring your grievances here? Congress writes laws. The judiciary interprets them. Do you now ask this court to legislate from the bench? Crockett's voice softened, but her gaze stayed firm. No, Your Honor. I'm asking the court to defend the laws Congress already wrote, the Voting Rights Act, the 14th and 15th Amendments. They are being eroded not by legislation, but by reinterpretation. Thomas folded his hands. So you disagree with this court's interpretation of those provisions? I disagree, she said, with interpretations that protect power over people. The Chief Justice shifted in his chair. Representative, the court must remain neutral. Political accusations are not proper before this bench. With respect, Mr. Chief Justice, Crockett replied, neutrality is not always justice. Silence, too, is a choice, one history remembers. Justice Kavanaugh spoke for the first time. Representative, you suggest discriminatory impact equates to discriminatory intent. But where is your evidence of direct intent by the Texas legislature? Crockett glanced at her notes, then looked up. Senator Dorsey's committee remarks, recorded in public record, stated explicitly that these measures would tighten the ballot for those who shouldn't be voting anyway. When asked who he meant, he referenced, quote, urban districts and college voters. That intent is in the record, Your Honor. A brief pause followed. Justice Barrett leaned toward Thomas, whispering something inaudible. Thomas simply nodded once. He then addressed Crockett again. Representative, you've quoted one state senator's comment to indict an entire law. Are we now to judge motives by rhetoric rather than text? Crockett replied evenly. When rhetoric guides legislation, yes. Because words reveal motive, and motive guides policy. Law does not exist in isolation from the people who make it. Thomas exhaled softly. You speak eloquently, but you risk confusing moral outrage with constitutional doctrine. Moral outrage, she said, is what birthed every constitutional amendment after the first 10. Outrage against slavery, against disenfranchisement, against discrimination. Without moral clarity, the Constitution is just ink. The audience murmured again, softly, respectfully, but audibly enough that the Chief Justice tapped his gavel once. Order, please. Crockett paused, lowering her tone. Your Honors, the Constitution has endured because it was meant to be challenged, meant to be reinterpreted as the nation evolved. What was once revolutionary becomes foundational, and what is foundational must sometimes be rebuilt. That's not rebellion. That's responsibility. Justice Thomas watched her closely. For a fleeting moment, his face softened. You remind me of Thurgood Marshall, he said quietly. He, too, believed in the Constitution's elasticity. I clerked under him. He was a man of conviction, but he also knew the danger of ambition without anchor. Crockett's voice dropped to a respectful calm. Then you know, Justice Thomas, that he also believed in humanity before hierarchy. His anchor was people. Thomas looked down, perhaps remembering something distant, a different courtroom, a different decade. Then he straightened. We will take that under advisement. The Chief Justice nodded. Representative Crockett, your time is nearly concluded. You may make your closing remarks. She gathered her papers but didn't look at them. Your Honors, she said, this case is not about one state or one law. It's about whether democracy bends under the weight of convenience or stands firm under the promise of equality. The Constitution belongs to the people, not to the powerful. And today, those people are asking not for favor, only for fairness. A final hush fell. Even Justice Thomas did not immediately respond. The Chief Justice finally said, Thank you, Representative Crockett. The court will take this matter under advisement. As she stepped away from the podium, a journalist whispered to another, that wasn't an argument, it was a reckoning. Crockett didn't turn around. Her face was calm, but her hands trembled slightly, not from fear, but from the gravity of having spoken truth in a room built to test it. When the heavy oak doors of the Supreme Court chamber closed behind the last observer, silence once again claimed the great hall. The cameras were gone, the gallery cleared, and the echo of Representative Jasmine Crockett's voice still seemed to linger in the air like smoke after a storm. In a quiet side corridor, the justices walked toward their private conference room, an oval chamber paneled with dark mahogany and lit by an antique chandelier that had witnessed more than a century of constitutional debate. The air felt dense with the weight of what had transpired. The justices' black robes whispered softly as they took their seats around the polished table. Chief Justice John Roberts sat at the head. His demeanor was calm, but the small furrow between his brows betrayed unease. "That," he began quietly, "was one of the more unusual oral arguments I've seen in recent memory." Justice Elena Kagan gave a faint half-smile. "Unusual is one way to put it." She dismantled him, politely, methodically, and on his own terms. Across the table, Clarence Thomas said nothing. His eyes remained fixed on a folder of notes he had barely touched during the session. Justice Samuel Alito leaned back in his chair. She was theatrical. Clever, but theatrical. We can't let emotion cloud constitutional interpretation. Justice Sonia Sotomayor interjected. "It wasn't emotion, Sam. It was precision." She cited his own words, both from the bench and from his memoir. "That's not theater. That's preparation." Alito raised an eyebrow. "Preparation doesn't make her right." Justice Ketanji Brown Jackson, sitting quietly until now, spoke in a steady tone. "Maybe not. But her argument was rooted in something this court has been avoiding, the intersection between lived experience and constitutional law. She forced us to look at the human impact of our rulings." Thomas finally looked up. His voice was low, deliberate. "We interpret the law. Not feelings, not memory, not anecdotes." Jackson's gaze held steady. "Sometimes those things are the law, Justice Thomas. They're the reason amendments exist." Roberts lifted a hand, forestalling further debate. "We're not here to relitigate the argument. But we all saw what happened in that courtroom. Justice Thomas, your exchange with Representative Crockett." Thomas cut him off, his tone even but sharp. "Was within decorum. I asked a question." Kagan's tone softened. "It wasn't really a question, Clarence. It was a dismissal. And she turned it into a constitutional discussion that exposed contradictions in your record, ones that resonated." For a long moment, no one spoke. The ticking of the antique clock on the mantel filled the silence. Thomas exhaled slowly. "You all seem to think I was humiliated." Roberts leaned forward slightly. "No one said that." "But that's what you mean," Thomas said, his deep voice tightening. "You think I lost control. That I allowed her to provoke me. Maybe I did. But I spoke the truth. Experience matters. She's been in Congress for a year. She's no constitutional scholar." Jackson replied softly, "And yet she quoted you from memory. Accurately. You should appreciate that. It means your words still carry weight." Thomas's eyes flickered, something between irritation and reflection. "She weaponized them." Roberts folded his hands. "Maybe. Or maybe she mirrored your own method, original meaning, drawn from real life. The irony is, Clarence, she argued like an originalist. She anchored principle in history, yours." The room fell into contemplative quiet. Justice Neil Gorsuch, who had said little, finally spoke. "Her performance doesn't change the text. But it might influence how the public perceives the court. The optics were unprecedented." Sotomayor nodded. "The court lost control of the narrative today. For once, the story wasn't about ideology, it was about humanity." Thomas frowned. "We are not actors for the public stage." "No," Kagan replied, "but we are custodians of trust. And when a justice belittles a young advocate, even subtly, that trust erodes." Thomas's gaze drifted toward the long window behind Roberts, where the Capitol dome gleamed faintly in the distance. The irony was not lost on him. He had once walked those halls himself, a young man full of conviction, misunderstood, judged by appearances rather than ideas. He closed his folder. "The court will deliberate as it always does," he said finally. "The noise outside will fade." Roberts nodded slowly. "It will fade, yes. But not before shaping how the public sees us. You've always said the Constitution speaks for itself. Today, someone reminded us that so does conduct." The meeting adjourned quietly after that. One by one, the justices departed, leaving Thomas alone with his thoughts. The ticking clock continued, marking time in a room built to withstand centuries. He sat back, eyes unfocused. Her words echoed again. Your own lived experience actually supports the broader precedents I've cited. He remembered his grandfather, the man who had raised him in Pinpoint, Georgia. The memory of that registration office flashing a closed sign when black citizens lined up outside. He had written those words himself years ago, believing them to be reflections of a painful past, not a living argument. Yet now, they had returned, not as nostalgia, but as indictment. The door creaked open. Chief Justice Roberts reappeared, holding 2 cups of coffee. He set one beside Thomas without a word and took the chair across from him. She surprised you, Roberts said simply. Thomas stared at the cup. She reminded me. Of what? That the Constitution isn't static, Thomas murmured. That's what Marshall used to say. I disagreed with him then. Roberts smiled faintly. And now? Thomas didn't answer. The Chief Justice studied him for a long moment before speaking again. For what it's worth, Clarence, she respected you. You could hear it in her tone. That's rare, these days. Thomas gave a small nod. Respect doesn't mean agreement. No, Roberts said quietly. But it makes disagreement civil. And that's worth something. For a while, the 2 men sat in silence, the gravity of decades of jurisprudence between them. Then Roberts stood, leaving Thomas alone once more. Outside, the city hummed, reporters drafting headlines, pundits dissecting every gesture, every inflection. Inside the Supreme Court's quiet chambers, Clarence Thomas finally opened his own memoir again. He turned to a familiar passage about his grandfather, reading the lines he had written years before. He believed in self-reliance but knew what it meant to be turned away, even when following the law. He closed the book and whispered to no one in particular, maybe she was right about one thing. By dawn the next morning, the nation had already moved, not on, but into the argument. Clips from the hearing flooded every corner of social media. The 3-minute exchange between Justice Clarence Thomas and Representative Jasmine Crockett had been clipped, subtitled, and set to dramatic music. On TikTok, users dissected the tone of Thomas's voice, slowing it down, analyzing his smirk. On X, hashtags like #CrockettClapback and #ThomasUnderFire trended side by side. YouTube commentators titled their reactions, "She out-argued a Supreme Court justice," or "The moment the court felt human." By 9 a.m., news anchors were already parsing every syllable. An unprecedented courtroom confrontation, said CNN's morning host. Representative Crockett challenged Justice Thomas not only on constitutional grounds but on moral ones. It wasn't a confrontation, countered a Fox analyst. It was a young politician grandstanding in the highest court of the land. At that same moment, in a modest cafe in Houston, Jasmine Crockett scrolled through her phone, shaking her head at the viral numbers climbing by the second. Her chief aide, Malik, grinned across the table. 2 million views overnight, he said. You know what that means? You just became the face of judicial accountability. Crockett gave a quiet laugh. Or the target of every conservative pundit in America. She locked her phone, the faintest trace of unease on her face. She hadn't gone into that courtroom looking for spectacle. She'd gone there to challenge what she saw as an erosion of democratic principle. But now, her calm, precise rebuttal had been rebranded as a mic drop moment. It's funny, she said. You try to talk about the Constitution, and people just want the clip where you raise your eyebrow. Malik shrugged. That's politics in the digital age. But maybe that clip will make people listen to the full argument. Crockett's gaze grew thoughtful. Let's hope they do. Across town, in the Supreme Court's private offices, Justice Thomas sat in his study, television muted. The headlines scrolled across the bottom of the screen, each one louder than the last. Crockett schools Justice Thomas in stunning exchange. Has the court lost its moral compass? Thomas faces generational reckoning. He turned off the TV and leaned back in his chair. For most of his career, he had thrived on silence, the kind that comes from not explaining, not defending, simply ruling. But this was different. The world outside the marble walls no longer treated the court as untouchable. Every gesture, every pause, every glance was now content for analysis. On his desk lay a letter, handwritten in careful script. It was from a law student at Howard University. Justice Thomas, I disagreed with you, but for the first time, I understood you. And I understood her. Maybe that's progress. He read the line twice. Then he set the letter down, unsure what he felt, vindicated, humbled, or simply tired. At Georgetown University, Professor Layla Hanif adjusted her glasses before addressing her packed lecture hall. "Let's talk about what just happened," she said. "This wasn't just a political clash. It was a jurisprudential event." A student raised his hand. "Professor, do you think Crockett was right? Did she overstep?" Hanif smiled faintly. "In law, there's no overstepping when you argue truth within precedent. What she did was expose the performative nature of judicial questioning." Thomas's reaction revealed how thin the line is between inquiry and ideology. The students nodded, furiously typing notes. "She didn't embarrass him," Hanif continued. "She reminded the nation that even justices must answer to reason. That's not rebellion. That's democracy." The lecture clip, recorded by a student, would go on to get millions of views of its own. In Atlanta, a radio caller's voice cracked with emotion. "I ain't never seen someone stand up like that to power. She spoke for people like me, people who get told they don't belong in certain rooms." In another call, an older man countered sharply. "She disrespected the bench. We're losing respect for institutions. That's dangerous." The debate rippled through communities like a widening circle in still water, each perspective reflecting its own America. By evening, Representative Crockett was invited to The Daily Show. She hesitated before the interview, rehearsing her answers in the dressing room mirror. The host's first question was predictable. "Congresswoman, how did it feel to challenge one of the most powerful men in the country and walk away trending worldwide?" She smiled politely. "I didn't challenge him," she replied. "I challenged the logic behind his interpretation. The Constitution is a living document, not a relic. My job was to remind the court that real people still live under those words." The audience applauded. But when the show aired, most clips circulating online cut everything except her line, "The Constitution is a living document." Sound bites, not substance, yet even sound bites can move minds. Meanwhile, conservative commentators sharpened their rebuttals. On one podcast, a host scoffed, "A freshman congresswoman lectures a Supreme Court justice, and the media calls it courage. Imagine if the roles were reversed." On another, a more tempered voice observed, "Whether you agree with her or not, that exchange symbolized a generational shift. The old guard met the new, and neither side blinked." Inside the court, younger clerks whispered in hallways. They'd seen the clip too, some with admiration, some with quiet discomfort. One clerk murmured, "She said what we think sometimes, but can't say out loud." Justice Ketanji Brown Jackson noticed the atmosphere as she passed through chambers the next day. She paused outside Thomas's door, then gently knocked. He looked up from his desk as she entered. "You've seen the fallout?" she asked. Thomas nodded. "It'll pass." "It might," she said. "But something changed. People are watching us differently now." Thomas gestured toward his muted TV. "They always watch differently after a spectacle." She met his eyes. Maybe it wasn't spectacle. Maybe it was reflection. He frowned. "Reflection?" Jackson smiled faintly. "You've always said the Constitution must be interpreted as written. But sometimes, even the text needs a mirror." Thomas looked down at the desk again. His hands, large and steady, rested on a copy of the Federalist Papers. "I spent a lifetime defending the original meaning," he said. "Maybe I forgot how many meanings there are to begin with." Jackson studied him for a moment, then said quietly, "Maybe that's why she got to you. She didn't argue law against you, she argued memory." And then she left him alone. That night, a slow rain fell over Washington. The Supreme Court building stood luminous under the streetlights, timeless, austere, impenetrable. But inside its walls, the echo of a single exchange between two generations, two philosophies, two histories, still vibrated faintly in the marble. For once, the power of words had shaken something not in the law, but in the silence behind it. Weeks passed, but the echoes of that day inside the Supreme Court chamber refused to fade. The headlines had cooled, yet the debate smoldered like embers beneath the nation's political discourse. Every law school panel, Sunday morning show, and op-ed carried some trace of the confrontation, as if America had glimpsed a rare crack in the marble facade of its institutions. For Clarence Thomas, The silence afterward was louder than the noise that had preceded it. He returned to his routines, reading briefs before dawn, long walks through the courthouse gardens, quiet dinners at home. Yet something within him had shifted, subtly but irrevocably. He had built a career on discipline, a mind forged in resilience, a will sharpened by defiance. But this time, he felt something he hadn't allowed himself in years: introspection. One afternoon, he sat alone in his chambers, sunlight pouring through the tall windows, a copy of the Constitution open before him. His eyes traced familiar words he'd quoted countless times: "We the people." He murmured them aloud, his deep voice filling the still air. Those words had always meant strength, collective, enduring, absolute. But now, he wondered, who are the people when the law forgets their faces? He remembered Jasmine Crockett's voice, not the defiance in it, but the calm conviction. Your own experience proves that equality and liberty cannot exist in isolation. At the time, he dismissed it as rhetorical flourish. Now, it haunted him like a truth he'd once known and buried beneath layers of jurisprudence. In another corner of the city, Representative Crockett was experiencing her own reckoning. She sat in her congressional office late one evening, surrounded by stacks of constituent letters. Her assistant had compiled them into folders labeled support, criticism, and neutral. She opened the first one at random. "Thank you for speaking truth to power. You made us proud." Then another. "I respect your courage, but maybe respect goes both ways." And then another. "I watched you. My teenage daughter watched you," she said, "so that's what standing firm looks like." "Thank you." She smiled faintly and leaned back. The glow from her desk lamp cast a soft halo around the room. Despite the praise, she felt no triumph, only responsibility. She hadn't sought fame, only to make the law feel human again. But now, her name had become a symbol, and symbols have weight. Her phone buzzed with a message from Malik. "You've been invited to deliver the keynote at Howard Law's Spring Symposium." She replied with a single word: "Accepted." For a moment, she gazed out at the Capitol dome through her window. The same dome that Justice Thomas could see from his own chambers. Two people, two views, one city, bound by an argument that had transcended them both. The symposium came weeks later. The hall was full: students, professors, journalists, and even a few judges. Cameras lined the back wall, but Jasmine didn't flinch. She'd long accepted that words meant nothing unless they could withstand scrutiny. She stepped to the podium, adjusted the mic, and began. "When I stood in that courtroom, I wasn't trying to win an argument. I was trying to remind the court that the Constitution was written for people. Not for the marble, not for the robes, not for the headlines. Just people." The audience listened intently. Justice Thomas and I disagreed, profoundly. But disagreement is not disrespect. It's democracy. And democracy demands that we speak, even when silence feels safer. She paused, glancing down briefly before meeting their eyes again. "I've learned something from all this, that law without empathy is like power without restraint. It exists, but it cannot inspire." The hall erupted in applause. Cameras flashed, but for once, she didn't care about the viral clip that would emerge. She cared only that they'd heard her, really heard her. Across town, Clarence Thomas watched the speech from his office on a muted live feed. His clerks had gone home. The building was nearly empty. He studied her expression, her composure, her restraint. "She's not grandstanding," he murmured to himself. "She's growing." When the applause ended, he sat still for a long while. Then he rose, walked to his bookshelf, and pulled down a well-worn volume, his own memoir, My Grandfather's Son. He flipped to a section he hadn't read in years, the passage describing his early days in law school, when doubt was his constant companion. His eyes lingered on a line he had once written with absolute conviction. "Every man must own his convictions, even when they lead him into loneliness." He smiled faintly. "Maybe loneliness," he said softly, "was never the point." A week later, the two met again, this time not in a courtroom, but at a private symposium dinner in D.C. It wasn't planned. Fate, or perhaps irony, had placed them at the same table. When Crockett arrived, she noticed him first, seated quietly, a glass of water beside his plate. She approached with a polite smile. "Justice Thomas." He looked up, his expression unreadable. "Congresswoman." They exchanged a brief handshake, firm, professional. Then, after a pause, he said, "You spoke well. Better than most who've stood at that podium." "Thank you," she said. "I wasn't sure you'd be watching." He gave a dry half-smile. "I always watch, especially when someone quotes my own words against me." She laughed lightly. They seemed to fit the moment. He nodded, serious again. They did. A moment of silence passed, filled with quiet respect. Finally, she said, "You know, despite how the media painted it, I never wanted it to be personal." Thomas met her eyes. "It wasn't. It was necessary." She studied him for a moment, sensing sincerity beneath the gravitas. "Necessary?" "Yes," he said. "Because the court doesn't listen well anymore. Maybe we needed to be reminded of what it sounds like when someone speaks plainly." She smiled. "Then I'm glad I did." Thomas inclined his head. "So am I." Later that night, as they went their separate ways, the city seemed to hum differently. No fireworks, no headlines, just two figures walking away from a shared crossroads, one returning to the marble quiet of the court, the other to the charged corridors of Congress. And yet, something between them, between generations, philosophies, and experiences, had found an uneasy understanding. In the days that followed, pundits moved on, the news cycle churned anew, and America found fresh controversies to consume. But somewhere beneath the noise, the echoes of that singular moment endured, a reminder that words still had power, that argument could still inspire, and that truth, once spoken plainly, had a way of settling deep into the fabric of a nation. In the stillness of his chamber one evening, Clarence Thomas wrote a note in his own hand, not for publication, not for history, just for himself. "The Constitution endures because it belongs to the living, and so must its interpreters." He folded the paper neatly and slipped it between the pages of his memoir. Outside, the Capitol lights shimmered against the night. Somewhere, Jasmine Crockett was still working late, her own desk covered in drafts, bills, and dreams of reform. Different paths, same purpose. And in the quiet symmetry of that truth, the nation, weary, divided, ever questioning, found its rarest form of justice, understanding.